Why can't farmers reuse their own seeds? The answer might surprise you. Imagine you're a farmer. You buy seeds, grow your crops, harvest them, and like generations before you, you save some seeds to replant next season. Pretty normal, right? Well, if you're using certain genetically modified seeds, that simple act could get you sued. Today, we're diving into why farmers can't legally replant their own seeds and how a company like Monsanto made that possible. It all started with a herbicide called Roundup. Developed by Monsanto, it contains a chemical called glyphosate that's incredibly effective at killing weeds. But there was one big problem. Glyphosate doesn't just kill weeds, it kills crops too. So Monsanto created a solution: Roundup Ready seeds, genetically modified to survive glyphosate sprays. This gave farmers a huge advantage. They could spray entire fields with Roundup, wipe out the weeds, and keep their crops unharmed. Here's where things get complicated. Those Roundup Ready seeds are genetically engineered. Their DNA has been modified in a lab. And because they were created through innovation and biotechnology, Monsanto was able to patent them. A patent gives a company exclusive rights to its invention. In this case, the genetic traits inside the seed. So when a farmer buys these seeds, they're not just buying a bag of grain, they're buying a licensed product protected under intellectual property law. Replanting those patented seeds is legally considered patent infringement. To buy Monsanto's GMO seeds, farmers have to sign a technology use agreement. This contract clearly says, you may plant the seeds. You may not save or replant seeds from your harvest. You cannot share or sell those seeds either. So even though the crop grows and produces new seeds, the farmer can't legally reuse them. They have to buy new seeds every season. Farmers who save and replant patented seeds have been investigated, sued in court, and forced to pay huge fines or settlements. One major case, Monsanto versus Bowman in 2013. A farmer bought Roundup Ready soybeans from a grain elevator and replanted them. The Supreme Court ruled against him, reinforcing that patent rights apply even to seeds harvested from legally purchased crops. So how did herbicide use lead to all of this legal trouble? Let's break it down. Monsanto developed Roundup. Farmers needed seeds that survive it. Monsanto created Roundup Ready seeds. Those seeds are patented. Farmers want to use them. They must sign legal agreements. The agreement bans saving seeds. Reusing equals patent violation. Patent violation equals lawsuits. Farmers pay fines or settle. Basically, a weed killer created the demand for a patented seed, and that seed came with legal strings attached. Supporters argue the system drives innovation and helps biotech companies recover R&D costs. Critics say it traps farmers in a cycle of dependency, buying new seeds year after year, while giving corporations enormous control over the food supply. This issue has sparked global debate about the ethics of seed patents, food security, and corporate influence in agriculture. So, the next time you hear about GMO crops, remember, it's not just about science, it's about patents, contracts, and control. Farming may be one of the oldest human traditions, but in the age of biotech, even saving seeds can become illegal. What do you think? Should farmers be allowed to replant seeds from GMO crops? Or are patents necessary to protect innovation? Drop your thoughts in the comments below. Like if you learned something new, and subscribe for more deep dives into food, science, and law.